in June. Joan Wilcox is present by Zoom, and she had practiced a little bit over the weekend. Also present is Cezanne Barta for Capital One. Let me make a note here. This is a claim for $4,470.56. Plus cost, interest, and attorney fees. We had a hearing on June 23rd. Hannah McNeese was here for plaintiff. The defendant indicated she was working with a debt consolidation company. She had no money, and the matter was continued until this date. Plaintiff filed a motion for summary disposition. Ms. Wilcox, I explained at that time that a motion for summary disposition is a motion generally filed by the plaintiff that essentially states a judgment should enter on behalf of the plaintiff because there is no material issue of fact and the defendant hasn't stated a defense. They filed a motion and a supporting brief detailing their opinion that I should enter a judgment on their behalf. Mr. Barty, anything to add regarding that?
I do not, Your Honor. We can rest on that motion. If the court has any questions, I'll be willing to answer anything.
Ms. Wilcox, what's your position here?
My position has not changed. Like I said, this was turned over to Consumer Legal Group on September 22. I thought everything was fine. I had not heard any billings or anything from Capital One. Had they let me know that they weren't receiving a payment, then I would have took care of it then. My situation hasn't changed. I have no money, and I can't get Consumer Legal Group to answer my phone or admit to anything. But this was turned over to them on September 22. My situation has not changed.
All right.
I still just get the Social Security, and it takes every penny that I have to support this house. And
all right, Ms. Wilcox, if you don't have any money, you don't have any money. They can't garnish your Social Security. They can't seize your assets if you don't have any money, but your circumstances could change. You may have gotten a raw deal from Consumers Credit Group, Legal Group, and some of these debt consolidation companies, the people end up in much worse shape than before they started. I don't want to paint them all with the same bad brush, but I've seen a lot of sad stories about people that who were in worse shape afterwards. I've also seen a number of stories where the people successfully completed the payment with the debt consolidation group. At any rate, it does appear that plaintiff is entitled to motion for summary disposition to be granted. Mr. Bart, I was looking to see if I had an order in here, and I don't. If I got it, I'm missing.
Your Honor, I don't believe I see one in the motion that we filed with the court, so I can submit one today.
I understood that one of those things they wanted me to sign is that they could audit my checking account anytime they wanted to, and I don't agree with that.
Well, you don't have to. I'm trying to break this motion down It's just a lump sum, 4,470.56. It's not broken down between costs and damages. 4,470.
I had it paid down to 2,400 when I turned it over to them.
Your Honor, the damages amount that we filed suit for is $4,470.56. There are no costs, attorney
Yes,
fee, or interest.
All right, I'd ask you to send me a copy, an order for summary disposition. You can email it. It's at 3bcivil@stjosephcountym.org. It's the same address that's on the notice.
Perfect, Your Honors. So that was 3B Civil at ST Joseph County.
mi.gov.
Perfect.
Ms. Wilcox, I just made a finding that they are entitled to summary disposition that you owe this money. They didn't ask for any cost. They didn't ask for any attorney fees, just the damages that they pled for. But you don't have any money. So as a practical matter, they're not going to be able to collect anything from you. As I indicated, they can't take your Social Security or seize any of your limited assets. However, if your circumstances change, you inherit money, you win the lottery, somebody gives you money, they could collect from that. I will give you some advice. Do not commingle any other funds with your Social Security checks. It makes them subject to garnishment. So make sure any money, the only money that goes in those accounts is your Social Security and other perhaps pension benefits. So they did file a written brief and a motion, which you got, but it's in legal language. But essentially it says there is no material issue of fact and there's no defense. You may have gotten taken advantage of by Consumers Legal Group, but that is not a defense that you owe this money to Capital One. Are you still on South Grant Street?
I am.
My mother grew up on South Grant Street in a little house that's still there many, many years ago.
Where is that at?
It's about at Grant and Buck.
Oh, it's
I'm not
further
sure.
down then. I'm on the corner, almost on the corner. I'm between Spring and Hill.
Okay. All right, Ms. Wilcox, this is a situation of it just is what it is. You owe this debt, but you don't presently have the ability to pay on it. They're going to send you this order. I'll sign it. You can talk to them, but right now, you don't have any ability to pay on it, but you do owe the money. The fact that you don't have any money isn't a defense to the fact that you owe money. So essentially, not much is going to change in your circumstance, although I made a finding that you owe this debt. All right, do you have any questions?
No, and I'm not saying that I don't owe it. I just can't pay it.
I understand, and so do they. All right, you're good to go.
Thank you, Your Honor.
Thank you.
What have you got?
Mr. Michael Alexander, he's at 9:35. Are you ahead or?
Michael Alexander.
I
No,
didn't look, Judge, you said he had 9:35.
for what?
That's a pre-trial.
I don't have a
He
Michael.
was in the lobby, and we got busy, so I was afraid I missed him. Elaine was setting up the Zoom.
Well, I don't have
Your
it.
Honor,
Oh,
I have
yes.
notes on the
He's
docket.
9:45.
And
Yes.
access OneDrive right now.
Yes, so he's here. Okay.
All right,
That is why-
Your notes on the docket are on the computer.
Yes, I printed the docket off and forgot to pick it up.
That's fine.
So they are on a computer and OneDrive's not working, so I just need to get
All right,
to email it to me.
then do you want to just pass this for a little bit?
Yes, I'm so sorry. I did
All right.
not
It's not a problem. That's the reason I use a paper calendar though.
Adam, it's docket for the record, and I forgot to grab off the printer. That is on me. So sorry.
Thank you. All right. Who else do we have? Who do we have next inmates?
Just the one. Just.
Oh, she's on page 11.
What are you doing? The inmates
right now, so she.
Your Honor, if we could pass this one, please, I'd like to speak with the probation officer. I believe that we're going to have.
All right, we'll put it on the second call then.
Judge, she hasn't even been arraigned under appeal.
It is for an arraignment, so let's go ahead and provide. Have you obtained a copy of this violation of probation?
Yes.
All right, well, we'll give you another copy then. So. And do you wish a formal reading of that?
No.
Oh, so a formal reading has been waived and we'll enter a plea of not guilty. We'll put it on the second call to see if is it Pascal?
Pascal.
Pascal, right. If Ms. Pascal can work anything out, if not, we can give you another date for a hearing. Well, thank you.
I'm sorry, who?
Fix.
Yes.
Yeah.
Your Honor, this is Mr. Phipps, I believe, license request passes.
All right. Do you want to pass it to second call? What is his name again?
Mr. Phipps. P-H-I.
Phipps. Okay, page 8.
What's his first name?
Jason.
Jason William Phipps. All right, we'll put it on the second call.
Thank you. Rory.
First name? Dalton. Dawson.
Rory Dawson. Rory. Clemens, this is your client.
Yes, Your Honor. And I believe we have an agreement on this, Your Honor.
We do. Mr. Clements is going to announce it,
Yes.
because I do not have access to my notes.
Yes, ma'am.
So sorry.
Your Honor, thank you for your patience.
So we got yes. Please spell your first and last name for the record. Stephen Plotnick.
Yep.
STV9KWASNY.
All right, very good. You may inquire.
Thank you, Your Honor. And I want to make sure I'm saying that last name right, because I think I've mispronounced it a few times. Is it Quasny? Okay. Mr. Quasny, could you please tell the court where you lived in 2018?
914 Julie.
Okay. As far as you know, is that city of Ann Arbor, state of Michigan, and Washtenaw County?
Yes.
Thank you. And in early, excuse me, 2024, around January, February, did you walk into Ann Arbor Police Department station to report a crime?
Yes.
Okay. And did that crime that you're reporting involve a Larry Lee?
Yes.
Do you see Mr. Lee in the courtroom today?
I do.
Could you please point him out, describe something he's wearing? Could you describe what he's wearing?
A jail outfit.
Thank you.
Hold on one moment, Ms. Banner. The two people in the front row, you need to back up one row, both of you. Excuse me. Yes, you guys just need to back up one row. All right, just that first row needs to be empty. Thank you.
Your Honor, may the record reflect the victim identified the defendant, pointed him out in the courtroom at defense counsel's table.
That objection record shall so reflect.
Objection.
Thank you, Your Honor. And what you reported, where did that take place?
My home.
At that Dewey Street address you just mentioned? Okay. And can you please tell the court what you reported happened? When you say he, who are you referring to?
Larry.
Mr. Lee, defendant?
Yes.
Thank you. I'm sorry, I just have to be really clear for the record.
Yeah.
That's why I keep asking you questions. I'm going to ask you some questions about what happened and what you reported. When I'm done asking questions, defense counsel might ask you questions, okay? If you need either one of us to rephrase anything, please let us know, okay? And you said you reported something that happened in 2018. Do you remember approximately when during that year it happened? Okay. And who was in your apartment when this crime happened?
Just Larry and I.
Okay. Can you tell us what had happened earlier in the evening? At what point did you get to your apartment?
So, I had people come over from after bars one night. Never met Larry before. He came with another friend that I don't remember who she was, but it was another girl. We had a drink at my place. He asked kindly to stay over because, well, everyone started to leave. It was done the night. He asked to stay over because he was too drunk to drive, so I let him stay over. And,
I want to just pause you there. So he asked to stay over because he had been drinking.
yes.
You let him stay over. At that point, had he done anything to make you feel like that would be a concern of yours for him
No.
to stay over? Okay. Good. Well, go ahead. What happened after you allowed him to stay over?
So I fall asleep. I wake up to him in my bed, buck ass naked, stick out.
Okay. I'm going to go back a little bit and then we'll get to the details. Okay.
Of course.
Before you went to bed, you indicated he was staying at your place. Where was he supposed to be sleeping?
On the couch.
Okay. Before you went into your bedroom, was he on the couch?
Yes.
Okay. And had you indicated, excuse me, had you indicated to him that that's where he was going to be sleeping?
Yes.
Do you remember approximately what time it was? Was it early, late?
6, 7.
Okay. And had everybody been at your house and kind of drinking and just spending time until then?
Yes.
So he's on the couch. You're going to bed at that point in your bedroom?
Yeah.
Thank you. Had you, can you describe just to the court very briefly the layout? So where's the living room in relation to the front door and where's your bedroom?
They're pretty close. It's not a very good place.
Okay. So you went to your bedroom, were you starting to get ready for bed or were you already in bed when Mr. Lee entered? And what's the first thing you noticed?
His dick was out.
Okay. Were you awake? How did you wake up before you saw that?
Abruptly.
Okay. So you're sleeping in your bed, and I'm gonna ask you to be a little more detailed if you can. You're sleeping in your bed. What's the next thing that happens that you remember? And did that wake you up? His presence? Okay. And when you wake up and you open your eyes, what did you see?
Yeah.
Mr. Lee, is that who you're referring to?
Yes.
Okay. And if you remember, did he have any clothes on?
No.
No clothes on at all?
I mean, like his shirt was kind of off, his pants were down, like they were like around like his like knees or something.
Okay.
So
were you wearing any clothing in bed?
yes.
And so you wake up, you see Mr. Lee, and you said his penis was exposed?
Yes.
Do you remember if he was doing anything with his penis?
And, like at that moment, I was kind of scared for my life. It's the first night I ever met him, and you know, it's not a fun situation to wake up to.
What happened next? So you wake up, you see Mr. Lee, his penis is out. What happened next?
I asked him to get the fuck out of my house.
Okay. Did Mr. Lee get closer to you or do anything to your body?
He was resisting.
Okay, can you tell the court a little bit more about that,
So he
please?
was trying to suck on my pants, saying it'd be okay, don't have to tell anyone. And then I just kept yelling, screaming. It was just waking up at the time.
So at this point, because you saw when you saw Mr. Lee, I want to go back a little bit. When you saw Mr. Lee, how far was he from your bed?
He was in my bed.
He was in your bed already. Okay. And then what's the next thing he did? You said he tugged at your pants?
Yeah.
Okay. As he's tugging at your pants, is that when you were telling him to get out and yelling?
Yes.
And what was he able to move your pants down?
No.
Were you fighting him?
Of course.
Do you remember, or were you laying on your stomach, back, or side?
I'm on my stomach.
So as he's tugging at your pants, where on your body? I know this is, silly question because we know where pants are, but where on your body is he touching as he's pulling?
My face.
When you screamed at him to get out of your apartment, did he leave right away?
He resisted.
Did anything happen after he was tugging at your pants to pull them down?
No.
And you said he was saying some things to you.
Yeah. Just let it happen. It's okay. I want to tell anyone.
And what in your mind did you believe that to mean? Just let it happen. Let what happen?
Like, to try to sleep with me.
Was his penis out during all of
Yes.
this whole interaction? Did he eventually leave?
Eventually.
Do you remember approximately how long it took for him to leave?
5-10 minutes.
Can I have a moment, Your Honor?
Yes.
What was going through your mind as Mr. Lee was tugging at your pants with his penis out?
I was scared for my life. Never met him before that night. Didn't know who he was. Just in my bed. Doing that. Never experienced anything like that in my life before.
What was going through your mind once he left your apartment?
How that could have happened? Because the situation goes from trying to do him a favor, not like trying to drunk or anything like that, to now he's ass fucking naked in my bed.
Can I ask you to try not to cuss in the courtroom? I know you're upset, but we're gonna try to be as polite as we can, okay? Did you think about reporting the incident?
I wish I would have. But no,
Can you tell Dakota a little bit about what was going through your head that you didn't at the time?
like, you usually don't talk about, like, if something like that happens, it's hard to talk about. This is.
I don't want you to go to any details, so just yes or no answer. Did you end up running into Mr. Lee later on in 2023?
Yes.
December of 2023, roughly?
Yes.
Again, same thing. I don't want you to go into any details, just yes or no. Did you end up running into Mr. Lee sometime in January of 2024?
Yes.
Without going into what you've said, have you talked to other people about this since 2018?
Absolutely.
And has that had an effect on how you feel or how you felt about reporting it?
Yes.
Okay. Again, without going into what anyone said, can you tell us a little bit more about that? Sure. Can you tell us kind of what your mindset was and why your mindset changed?
Once I learned that he's done this to others and he's continued paying for it, I mean, I started to think something. Because he has a long history of harming others.
One moment, Your Honor.
Yes.
No further questions at this point, Your Honor. Thank you.
Cross-examination.
Good morning. I'm just going to ask you a series of questions. If you could just sort of follow along and answer them as they come at you. This was an event that was reported to the police initially in 2024. And this was an event that occurred that you're testifying to back in 2018. And in 2018, you did not go to the police. In 2018, you testified that he came to your residence. That's correct. And do you know who he came with? How many people came to your house that evening?
There was 4 total counting.
Who were the other individuals?
Yeah.
What you said you were at a bar. What bar were you at?
What's important is.
No, I'm just,
The answer.
you could answer my questions.
You didn't come to us from the bar, you joined through.
Okay,
So.
fair enough.
So you were at a bar. Which bar were you at? And what day of the week was this? It wasn't during the week? You said a second ago, he came with somebody else. He didn't come directly from live. How did that other girl that we don't know to come over to your house?
She came with the other person. I was kind of fuzzy. It's like when you go through a traumatic experience like that, it's kind of.
No, you just got to say what you remember. So this other girl had been in contact with you to come over to your house, or was it that other girl through somebody else? Okay, so you said there were 4 total. Was that including you?
Yes.
Okay, so you invited one person. How many people did you actually invite over? And 4 came. 3 came. Did they all come in your apartment together? You know, if they separate times, who came first? And then who came second?
Like I knew where they were at, it has to be in this room for how many times.
Okay, so you just brought up another buddy. You said there were 4 people there. How many people were over there?
4.
Okay. So you said they came together, or they came at separate times?
They
Okay,
came together with another girl. I knew the girl's name. I remember the girl's name.
okay, so he comes with somebody else. When did somebody else come? Okay, is that something you remember, or you're just trying to put together today?
No, this is something I remember.
Okay. About what time did they come to your residence?
2:30 somewhere.
What was the intention of all these people coming to your house at 2:30 in the morning?
I'm going to object, Your Honor. He can't speak to what their intention was. He can only speak to what he.
I'll sustain the objection. You need to rephrase your question.
Okay. You were invited people over. What did you plan on doing with all these people?
You know,
Okay, was there alcohol involved?
Yeah.
Okay. Had you been drinking at the bar? Okay, about how much did you had to drink that evening? And what were you drinking? Okay. What time did you get to the bar that day? And you were there till close?
Yeah.
What time did they close? Don't close at 3 or 4? Close at 2? Okay. So how well do you, outside of this defendant, how well do you know the other 2 people that were with you?
The one girl, sure, whatever money was theirs.
Okay. How did you get home? Okay. Do you know how these other individuals that came, do you know the other individuals live?
No.
Did you ever know where this defendant lived?
Not close.
About what time did the other 2 individuals leave? Okay. Do you know if they left by, do you know what transportation they left in? Did they,
Some took Uber, some drove. What's important is that he asked to stay.
okay. Did you ask him where he lived? He is basically he's a stranger to you. So you said it was a small apartment?
Yes.
You guys were all sitting together? There was lots of conversation that evening, early morning?
Yeah.
Did you get to know him while you were there?
A little bit, but like just kind of listen to music and just hung out, you know, like, that was common for what I would do back then. But music, have people over most of the time, I know this would be the last time I ever let someone in my home. That I know.
He asked to stay. You said, why don't you take an Uber home?
He said too drunk to drive. He asked to sleep on the couch.
You didn't say, can't you walk home?
Say those things before. Asked to stay. When I'm sleep on the couch, obviously I knew it was gonna happen. It was gonna happen. But in the house, I knew it was gonna happen.
And you said he was intoxicated? Did you watch him drink at your house?
Yes.
You know how many shots he had, or what were you drinking?
I can't remember what he was drinking. It was either whiskey or tequila or vodka. Those are the kind of things I had in my house.
How much did you drink at the bar and how much did you drink in your house?
Like, I see where you're getting at with all this. No, you just need to. I had probably 4 or 5 drinks at the bar, probably 1 or 2 drinks at my house.
You say he woke up. Do you think that he, let me rephrase. After this evening, did you ever have any additional, did you ever hang out with the other 2 people outside of this person?
So anytime I would run into him, it was like over the course of the years, like I work different marketing or event planning enrolls in different parts. He was always addressed as a priority threat.
No, strictly the other two people that were there, did you ever run into them?
The girl, no, like, probably, but I don't know. This is something just can't recall.
You never told them what happened.
No,
You didn't go to the police the next day.
no.
You didn't call the police that evening. And this would have been about 4 or 5 in the morning.
This would have been later in the morning, like 6 or 7. Everyone left at 4 or 5. He stayed over. I fell asleep. I woke up to him. Fucking idiot. Excuse my language.
So you didn't call the police. Did you? You said it took them 5 to 10 minutes to listen to you to leave.
Yeah.
You woke up and he was standing up.
He was in my bed. Right. You've been listening to this.
Does he, after you start screaming at him, does he stand up?
No.
Well, the question is, does he stand up at some point? I mean, he doesn't crawl out of there. Sometimes he stood up from the bed. Okay. So how many minutes were you screaming at him to get out of the bed? Took you 5 minutes to get him out of the bed? And when he stood up, how long between did it take him to leave? I could have him over here.
Yes.
Did you have the TV on? Was there light in the room when it was dark? Okay, so it was pitch black.
It was still light because the sun was out.
Okay, how many windows do you have in your room? Can you tell me what type of tattoos you saw on his body?
I just remember his dick and long fucking hair.
When you say his hair, where was his hair? What you're describing it as blonde.
Yeah.
Well, what part of his body? Does he have any tattoos on throughout his body?
He didn't have the facial tattoos they did today.
Okay, but on his torso, did he have any tattoos?
Can't recall.
And did you ever text anyone about this occurrence?
Recently, absolutely, not all the time.
Thank you. Can you redirect?
Just a few questions here. Thank you. Mr. Quasny, you mentioned that this was just one of those situations where you were out, you were drinking, having fun, and then people came over to your house to hang out. That's something that at the time would happen frequently.
Yeah.
And was it a frequent occurrence to have their friends join and just kind of come to your place to hang out? After what Mr. Lee did to you, did things change?
Absolutely.
Okay, can you tell us a little bit about that?
So one of the things that stopped having people over as often is stuff kind of catches up with you, kind of, but something like that happens. Rethink your life. How you put yourself in those situations.
So would it be fair to say that what Mr. Lee did to you had an effect on your life and mindset? And how has it felt having to show up to court a few times and testifying today?
Well, at least we're speaking today.
Is it easy for you to talk about what has happened to you?
It gets easier as I have to talk about it more often, but it's not easy.
Thank you. Nothing further.
Anything else? No. You may step down. Thank you, sir. Call your next witness.
Your Honor, people don't have any other witnesses.
Any witnesses for the defense?
No, Your Honor.
So, Your Honor, a few things. First, I would motion for bind over on the count we have in the complaint currently. I would also motion to add count 2 of indecent exposure. That's under MCL 750-335A2A.
335A.
Let's see, 335A. That's actually it's a 1-year misdemeanor and or $1,000 fine. So I just ask that follow along with the felony.
Argument. Udricus?
Argument?
Yes, as to the bind over.
As to the bind over, obviously, I know the court has the ability to weigh the credibility of this witness. This is an event that occurred 6 years prior to the date of the reporting. His testimony was a little bit fuzzy about who he was with. And the occurrence of having knowledge of this event would have been more clear in his mind, having somebody come to his house with another girl that was, he testified that was a friend. He can't recall who that friend was. And he doesn't recall who his other buddy was, but he would call them buddy and friend when he doesn't even know their name. I think that's an indication that along with the intoxication that he had been drinking since 9, had been drinking all the way up until 4, I think his memory might be a little bit fuzzy about the situation. I just don't think that there is enough question of fact that this actually occurred. So I'd ask the court to not bind over on either counts 1 or counts 2.
I don't need argument. Court, in listening to Mr. Quasnick, I guess I deeply disagree with the defendant's or defense rendition of his memory. Those things that certainly are important to him or were important from that evening, he is very vivid memory of. and gives a very visceral response when he's asked about it. As to, while it's certainly not relevant, I don't believe it's certainly something the defense may argue regarding the time. I also think Mr. Wisney explained that in that it was not something that he wanted to discuss, and that after as time went on and he was talking to other individuals, that's what led him to come forth. That is not uncommon, certainly in cases of sexual assault. So while those are arguments that the defense makes, I don't find them very persuasive. I do find his testimony as to what occurred that evening, or that evening into morning, I guess, to be very credible. I believe that telling the court the absolute truth about what happened, and that he was screaming for Mr. Lee to get out of his bed, and that it took some time, and he's very specific as to certain comments that Mr. Lee made regarding that. So for those reasons, the court would find that the people have sustained their burden and would find a defendant over stand trial on the criminal sexual conduct degree with the added count of indecent exposure following. You're going to need a new information on this with the added count to that. So are you waiving presentation of that?
You would waive presentation, Stan, you would ask for a free.
All right, defendant having waived formal reading, standing mute as to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for
October 7th at 1:30 with Judge Cummings.
October 7th, 2025, 1:30 before Judge Cuffey. Thank you.
With your honor's approval, we'd like to announce the following agreement. He is currently on a diversion. He's going to admit to violating the terms of that diversion, but not have his diversion revoked. Instead, be sentenced to time served and have his that's right. He's got to do a rehab as a condition of probation. Attention. And he's already secured and approved in our rehab program, and he's prepared to been accepted. It's his intention.
All right, so to make sure that we're all clear, he's going to admit that he's in violation of his probation, but
Yes,
revoked, but reinstated on time served.
Yes,
And
my recollection would not extend because he had it was so lengthy already. And I want to confirm with probation, so I know we've lost some notes. I believe it is not going to be extended because he has so many years left on his probation.
right, and so picking up where I was, then it's going to be revoked to serve his sentence, but suspended and reinstated on time served with the additional condition that he enter into and complete successfully a rehabilitation, an inpatient rehabilitation. Are those the terms of this agreement?
That is exactly right.
All right, then Mr. Roy, I need you to raise your right hand and let's have you placed under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, self be God. Thank you.
Thank you. State your full name for the record.
Dawson Axel Roy.
Mr. Roy, you're here today on a charge of violation of probation. I want to make sure that you understand your rights. Do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation? Do you understand that if we had that hearing, you would have the right to have a lawyer and have one appointed if you cannot afford your own, which of course we've done with appointing the public defender to represent you?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving the right to that hearing, to that appeal? All I'm going to do is approve what your lawyer and the state have agreed upon. And that's going to be to reinstate you to probation with this additional condition that you enter into and complete an inpatient rehabilitation program. You understand that? You understand that if you walk away from that or you get kicked out of that program, don't successfully complete it, then you're going to go to prison for the remainder of your sentence. You understand all of that?
Sir.
Right. You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty to the charge of violation of probation and waive your right to the hearing?
Yes, sir.
And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but by agreement with the state, and on time served, you'll be reinstated to probation and ordered as an additional condition of your probation that you enter into and complete an inpatient rehabilitation program that's agreed upon by your probation officer. All right, thank you. Good luck to you. Oh, and if he was on a judicial diversion, that judicial diversion is revoked.
Your Honor, the intention of the agreement was to not revoke his diversion.
How can you not revoke his judicial diversion if he's being found guilty of violating his probation?
It appeared, Your Honor, that it was possible to do so. Your Honor, to find that he had violated the terms of his diversion, to sentence him as you have, to change the terms of his diversion, but leave his diversion intact are what.
We were agreeing to that, Your Honor, if you would go to treatment. Mr. Clemens has some case law that says we would have to go to a sentencing hearing if we revoke.
Yeah, I mean, if we go to a sentencing hearing, I can sentence him within the range and give him more time than he actually got when he was placed on judicial diversion. So that's a choice he makes.
We'll probably need a second call this morning.
Thank you.
Well, I'm going to reserve the issue of the revocation of his judicial diversion until I look at any case law that may be provided to me, because my understanding is that you don't give somebody on a judicial diversion 2 or 3 chances and then still leave them on judicial diversion. First time they mess up, then that's the basis for revocation of the judicial diversion. And we'll see. I'll take a look at whatever case law you provide, and I'll reserve that issue.
Yes, Your Honor.
Right, that's Mr. Rory's judgment. All right, do we have anybody else? All right. We're going to then run through the regular docket till we're ready to take up the second call. On page 2 of the docket, 2024 CR 10, State versus Kelly Babcock. Kelly Babcock for a sentencing hearing. I assume that was because she was entering into a rehabilitation program. Oh. This is Monday, right? That's what happened. It feels like Monday. I think everybody's having a Monday. So.
We're talking about Ms. Babcock.
Yes.
So she is in a program. You had indicated on last cycle that as long as she's in a program, that's.
So she's in the program, so we just basically need to reset this. All right. Do you want to reset this? It's something I need to hear because it's a sentencing hearing. I
think the status was just the status that she was in a program. I think that was the reason for this.
Well, I'm back here in November, so let's put it for November. I'm not here in November. I'm here in December. Let's put it for December the 8th.
So is she still in the program? Does she need to report, or is she?
No, I just need to have someone report to me what's going on. 2025 CR 14, State versus Carly Bryant. Mr. Clemens.
Mr. Bryant is here, Your Honor. We'd like Your Honor, you're allowed to reset this for another status.
Okay, and why is that?
Got additional discovery that's being exchanged, and we'd like more time to look at that and potentially negotiate it. So,
Your Honor, this was a pro se case that went to grand jury, and it's she's an elderly lady, and she had trouble getting. She presented this case herself. She had trouble getting us the videos off my phone. And in the last 2 weeks, she has.
All right, Ms. Bryant, I'm going to reset your case for December the 8th. Make sure you stay in touch with Mr. Clemens, because that may be the last time that you have a continuance. And we'll set, if we we don't resolve your case by some sort of an agreement on December the 8th, then you're likely to have a trial date set. And once you go past that December 8th date, you will go to trial before a jury, or you will have to plead to the indictment and go to sentencing. Do you understand that? Any resolution you want to make by an agreement, you need to stay in touch with Mr. Clemens and let you all work that out between now and December the 8th. All right, thank you. 2023 CR 64, State versus Lewis D. Clary.
Morning, Judge.
Good morning.
Your Honor, that's state's motion to continue the TBI agent. I called her or emailed with her before trial, before I was going to issue subpoena, and I did it.
Any opposition to that?
No, sir.
Also,
We're still working on settlement too, so we might even get lucky on that and work it out, but.
All right, we'll reset it for my next term, which is in December, and that would be December the 9th, 10th, or 11th. Well, actually, we have a civil case set, a 2-day trial set on the 11th or 12th. It's a civil case. So it'd have to be the 9th or the 10th or the 5th.
December 9th.
December the 9th. All right, we understand this is going to trial then, and it
I'm
goes.
gonna go ahead and request subpoena.
All right. All right, matter will be set for trial December the 9th.
Second trial. Yes, wait for it. Thank you, Judge.
All right. 2005 CR 1467 State versus Jason Kleinert.
Yes, Your Honor, that's my petition on Mr. Kleinert. Mr. Kleinert was convicted by a jury as a juvenile tried as an adult. And shortly after the Booker decision, the federal government in the Sixth Circuit vacated the conviction. Mr. Kleinert, I have that case. My apologies to the court. My staple didn't go all the way through. It was quite the read. Mr. Kleinert, conviction's been vacated. So we're just simply asking the court to expunge that conviction.
State have any position on this?
We were going to defer to the court, Your Honor. Did y'all email this?
I didn't, I just filed it.
Well, my understanding is that the federal court has vacated the charge, and therefore, if it has been vacated by any court, either an appeal or by a federal court, then that would be a matter that would allow him to have his record expunged. So I will grant your request.
Do I need to prepare any order, Judge?
Yes, prepare an order, if you will, of expungement showing that it came before the court, set out the basis for your request, and also the fact that the court found that federal court having vacated that, that it would be eligible for expungement. So,
Yes. Thank you. Thank you, Judge.
Moving to page 3 of the docket, 2025 CR 30, State versus Cindy Lynn Compton.
For Ms. Wilkerson, she asked I stand in. I believe it's the first appearance. I'm spoken with the state or not. I think she's asking for one more recess.
There's no opposition to that, Your Honor. We also have a motion for additional discovery. We provided discovery, so I'm not sure.
The only thing I have is a status. So as far as this court is concerned, I will grant one more additional status day, and after that, it'll go to trial. I'll be set for trial. She'll have to plead to the indictment. But we'll set it for that December the 8th.
All right. Thank you.
Make sure you stay in touch with your lawyer and make sure that let Ms. Wilkerson know that's the last reset I'll give.
I'll let her know.
Thank you.
That's all I have, Judge.
You're welcome. Thank you.
Thank you.
2024 CR 53, State versus Gala G. Grice.
Your Honor, that's a case that I've been asked to stand in for Mr. Dave Walker to enter a settlement, which I believe he has been working out with the state. And we have ready to enter that second call if you'll allow us.
You want to pass it to second call? All right, we'll put it on second call, let you get it, the terms all nailed down.
Thank you.
Don't walk away yet, because the next case is yours as well. 2025 CR 32, State versus Renover DeLance Hill.
Mr. Hill? Your Honor, in this case, I think if the state's ready here to pick trial date.
Correct,
You
Your
got the 9th. I can give you the December the 5th date, but the other dates would be December the 9th and 10th, which we've already set one on the 9th. You want the 10th or the 5th?
I would prefer that we have a plea day before the trial day.
And that would be the 10th. All right, December 10th, Mr. Clemens will explain to you, Mr. Hill. This was your last opportunity today to resolve this case by an agreement. So from this point forward, you will go to trial or you will plead to every count of the indictment and go to sentencing. Those are the only two options that you'll be afforded from this point forward. Stay in touch with your lawyer. December the 10th for trial.
Thank
you. Also, Mr. Clemens, actually, the next ones are in custody, so. 2020 CR 83, State versus Stephen J. Jowl, Mr. Parks.
Which second call that?
Second call. 2024 CR 742, State versus Corbett Miller Jr. Corbett Miller Jr. All right. This case is set for trial tomorrow, I believe, on a Class C misdemeanor. Mr. Miller, you understand that you have requested a trial and I have assigned a trial date tomorrow for your case. You understand that?
Yes.
All right, and you are charged with a Class C misdemeanor, and you understand that a Class C misdemeanor doesn't carry any jail time. Therefore, it will have to be a bench trial. It won't be a jury trial because you are not entitled to a jury trial or to appointed counsel where you are charged with a Class C misdemeanor, which is only, you can hire a lawyer if you want one, but I can't appoint one for you because you're not facing incarceration in jail. You're facing a fine would be the only punishment that can be given if you're found guilty. You understand that?
Yeah, I understand. Yeah.
Okay. So are we ready for trial tomorrow?
I thought he had requested an attorney.
No.
I'm so
I done
confused.
seen
I'm so
two
sorry.
attorneys.
Pardon?
I've done seen two attorneys.
Okay.
And one's 5,000, the other is 10,000. And so it's a $50 fine. That's not the point. I'm not going to pay $50 because what I'm charged with is not right. What the code that got me charged with, I was on my own land.
Your Honor, the state had filed to continue. I thought he had filed for an attorney based on our conversation last week and was hoping he would get one. But he actually has another violation pending that was just sworn out this Friday, Your Honor, for hunting without a permit.
It's easy. Now, I told you a couple of weeks ago that I done seen two attorneys. I wasn't going to get another attorney. In the beginning of the first trial, this is going on 2 years. I've been here 3-4 times a year ever since the 1st of August 2 years ago. I don't even know what evidence they got. I haven't been told anything. I haven't been read my rights. I don't know nothing except the person that took a video of me unloading sewage on my property took a video, and I've got holding tanks out there that I use to unload my sewage in, because about 6 months out of a year, it's the only time I can get my truck out in the middle of 30 acres where I can spread it on 1 acre of ground. And so everything I've been charged with up underneath that code is actually obsolete. And the person, Jeanette, that's over this one, and I think he's a new guy. Anyway, he was one that sent me, and Jeanette sent me a certified letter about a week or so before this one did. It said if there's any discrepancies or anything that you need to say, call this number. And I called him 4 or 5 times. I got a hold of his secretary, and every time I'd call, he wouldn't be in there. And she said, well, I know one time, she said, well, I know he's in there. I just seen him walk in the office. And so I called him, and finally, after several phone calls, and then after she called me back, I finally talked to him, and I told him I've got two individuals down here that supposed to be checking my land, and Clarksville was in charge of it for the last 20 years. And all of a sudden, Clarksville, they closed Clarksville down. And nobody didn't notify me that Nashville was the one that was taking over it now. And I've got all kinds of papers where when I got a permit, when it was dry enough for me to get out there on my land, I've got about 13, 15 years of paperwork where they was sent back as far as October before I got the permit for that year instead of January the 1st, because I couldn't use and still can't use that land. And I got also that same year that I got the certified letter, I got 5 different times that I got pulled out of that pump truck trying to get back there in the middle of that 30 acres to spread that sewage the way it's supposed to be spread. And so I don't know what he's got, but whatever it is, that's the reason I want a 12-man jury.
All right, let me just say this. I misspoke because I wanted to double check, and you're charged with a Class C misdemeanor, but it does carry under the statute a sentence of not greater than 30 days in jail or a fine not to exceed $50 or both. So as a result of that, it is a case that he would both be entitled to appointed counsel if in fact he is indigent, and it would also involve a jury trial rather than a misdemeanor bench trial. So are you requesting that I consider granting you an attorney because you're unable to hire your own?
Yes.
Then I want you to raise your right hand. I'm just going to place you on oath for the purpose of filling out an affidavit of your income and expenses for me to determine whether or not you are qualified to have a lawyer appointed, okay?
Okay, I've done read that paperwork on and I wouldn't be qualified for it.
All right. Then
unless I sold a bunch of property.
So you own property, and as a result, you would not be qualified. All right, then he's not entitled to an appointed attorney. You had indicated that you've talked to 2 different attorneys and that the cost of hiring an attorney was exceeding what you felt like you wanted to pay. Is that correct? All right, so you're competent. You feel like you want to represent yourself at this trial?
Yes, I want to show evidence. First of all, I want to see the evidence that's charged against me. I haven't even seen it.
Your Honor, the state was hoping that a counsel would be appointed today, because if they are appointed, I'm going to move for a competency evaluation. I don't think that evaluation will happen unless there's counsel there to assist.
Well, he's not gonna have an attorney appointed for him because he's not indigent, and therefore he has declined to hire an attorney because of the cost involved. But as he stated, he owns property and therefore will not qualify for an attorney to be appointed. So for that reason, are you telling, is the state not ready to proceed on the case?
They are ready.
Then we will try this case to a jury tomorrow. We need a jury. All right. We will see you here at 9 o'clock for your jury trial. Okay. All right. Thank you.
Do I have to be here for this?
Hmm?
Do I have to be here for this tomorrow?
No, not for Mr. Mover.
Good, because I'll be working for Kim tomorrow in Champion.
Who do you work for?
Kim, or Judge Wallace in Champion. So I, okay, just wanted to make sure.
2025-052, State versus Darrell Ray Tanner Jr.
Your Honor, this is my motion to withdraw due to a conflict on this case.
Right, and your conflict is with the alleged victim in the case?
Yes, Your Honor, we represent her.
We have a plenty list. Well, we'll appoint Mr. Jay Runyon to, since he got some special treatment this morning, we'll appoint Mr. Jay Runyon to represent this defendant. So this is the no good deed goes unpunished rule. So, all right, we'll appoint Mr. Jay Runyon. Let me step off for just a minute. And Joe, let me speak to you. All rise.
It's right here, bud. It's right here, buddy.
All right, what we have here is a motion to withdraw that Mr. Stover has filed. Stover, you want to argue a motion?
Yes, sir. Yeah, I filed this motion based on the document I received from Mr. Powell, that I believe was a letter written to the court, copy sent to me, wherein Mr. Powell made certain statements about my representation of him in the case in the most renewed trial, which I believe created a conflict. And as such, I filed an instant motion in order to abide by the rules of professional conduct when there is a conflict between attorney and client that renders that representation problematic. Filed the motion, sent a copy to Mr. Powell, and filed the motion with the Court of Appeals. As you know, this case is for the Court of Criminal Appeals, so I filed that motion there as well. They have issued a stay in the resolution of the motion here for your honor.
All right. This is Mr. Stover's motion to withdraw based upon what he believes to be a conflict, an ethical conflict that has arisen. And although the motion for their trial has been resolved in this court, the Court of Criminal Appeals has remanded this case back to me for me to hear the motion for a new trial, motion to withdraw, and to try to make sure that the transcript is properly prepared. Of course, the problem that presents itself, had you been retained to actually handle the appeal?
Yes, sir.
And by doing, by filing this motion, it just means that Mr. Powell is going to either have to hire another attorney, or then someone's going to have to be appointed to represent him on appeal. And that creates an issue for me. Mr. Powell, what do you say about this situation?
I have no idea. I don't know.
Well, is there some reason that you're dissatisfied with Mr. Stover's representation of you on the appeal?
Oh, yeah. I stated that when in my motion, affidavit of truth, I stated what I believe wasn't proper for me. It wasn't what me and Mr. Stover agreed upon. There was no time for us to really come up with I never got to understand why certain things didn't happen. It was just kind of just rushed on through. Once you come and sit in these seats, you don't get a chance to speak for yourself. So when me and my lawyer discussed something, I expected it to be done. If we agreed on something, to be done in the courtroom. And when it wasn't done, I got no explanation for it. And I just felt I was rushed on through the whole process.
Well, do you understand that Mr. Stover is saying that you, basically by saying that you don't think he ethically or effectively represented you at the motion for new trial, that he doesn't feel that he can ethically represent you on the appeal?
I understand that.
And then if I allow him to withdraw, then you're without an attorney. And so the question is, are you able to hire another attorney to represent you? I know you or your family retained Mr. Stover. And Mr. Stover, are you in a position to, I don't know what the fee arrangements were, but if you're withdrawing and not handling the appeal, are you able to refund any portion of that fee to Mr. Powell's family so that he can retain another attorney?
Your Honor, I wasn't fully retained. I had a partial pay. And so I discussed that with his father. I would make a payment. That's I'll be an additional money. So there's so I'm not in a position to refund any money, but I'm not charged with the full fee either. So I have not fully.
I don't understand that neither. You was paid in full for the first for the motion for new trial. You was retained $5,000 for this. The next part you haven't done anything. We haven't sat down. We haven't met. So I don't see why you couldn't refund another $5,000. Refund that. You haven't done anything to anything. It was just a retainer, right?
You're telling this is not a point where you two get to argue about the money situation. What I'm suggesting to you is, number one, you got to have an attorney represent you on this appeal.
As far as that, Your Honor, I'm not sure where I go from here. Like, I've been abandoned this whole process, so I'm not sure what needs to happen right now. I don't know what to do. So if I can get time, I don't know the process. I don't know what's going on. If I can get time to come up with an attorney, or I'll be appointing one, then come up with one. I'm not sure. I'm going on the record saying I don't know right now. I have no idea.
Public defender has even on the appellate process, your office would have a conflict in representing Mr. Powell on appeal, correct?
So,
Mr. Stover, I understand your position, and my concern is that according to Mr. Powell, you were paid to represent him on the appeal. If I release you from representing him further, then I've got to appoint someone else who starts fresh in a case that they know nothing about. You've been involved in it for quite some time, so I'm going to deny your motion to withdraw based on the fact that it seems to me that Mr. Powell has got to have a lawyer that you are more familiar with it than anyone else would be, and that I could appoint, and that would delay his appeal. And right now, the Court of Criminal Appeals has remanded it to ensure that the transcripts were adequately and timely filed for this case. And if there's an additional time needed for the transcripts, then it was to be dealt with in this court. I understand your position and I've been in your shoes, but unfortunately, I don't find that there is an ethical basis just because Mr. Powell disagreed with how you handle his motion for new trial. That gives Mr. Powell the time to hire another attorney to substitute if he chooses to. But I think the Court of Criminal Appeals, it would be disinclined to allow you to withdraw on a case simply because he was critical of your handling on the motion for new trial. And as a result of that, we would be starting fresh, having to appoint someone completely unfamiliar with the case. And I would be appointing them to do so at the state expense, at the public expense, whereas you have been at least partially retained and familiar with the case. And as a result of that, I respectfully am going to decline your motion to withdraw. Mr. Powell, you can hire yourself another lawyer if you don't like what Mr. Stover is doing in your case. But right now, you've got to have a lawyer, and I'm not allowing Mr. Stover to withdraw based on the fact that you didn't like the way he handled your motion for new trial. He can handle the appeal and do what needs to be done for that. But if you don't like that, then you can hire another lawyer. You understand?
I'm not getting anything done. And now this has happened to you. I don't know how we can have a relationship from going forward. Now, he is definitely not gonna try to represent me now.
So who do you want to represent you? The question is,
I have no idea. To be honest, I don't know.
that's the reason I'm not allowing him to withdraw, because I don't know who I would appoint to represent you that could, if I appoint someone, another attorney, the public defender can't do it because they represented one of the party or had a conflict. So if I appoint another attorney and allow him to withdraw, then you are starting fresh with a pending appeal and the time constraints that are required for an appeal. You would have to start fresh from that. That person does not know anything about your trial, doesn't know anything about the case. Pardon me. And as a result, I do not find it would be in your best interest to allow Mr. Stover to withdraw and appoint someone else. Mr. Stover devoted months and filed detailed objections and statements of the evidence in your case, and filed detailed statements about the errors that he alleged were committed in your trial, and went through a laborious process of going through all of the transcripts of this trial. There's no one more familiar with your case right now that could handle your appeal than Mr. Stover. And obviously, if there's a monetary situation between him and your father, he can resolve that with your father, and you can hire someone else if you want to. But I cannot delay the appellate process by allowing him to withdraw and appoint a new person who knows nothing about your case. Does that make sense to you? You two are going to have to resolve whatever the issues are so that you can get this appeal moving forward. Because other than this issue and the transcript, it is out of my hands what happens with the appellate process. The Court of Criminal Appeals will handle everything from this point forward. So, Mr. Stover, I understand your situation. I think I've stated the grounds why I don't feel that I can allow you to withdraw at this point, and would ask that you continue in the case and make sure that your transcripts are filed timely. And then if he wants to hire someone else and his family does, then that's fine with me, and I'm sure it would be with the Court of Criminal Appeals, but there needs to be a substitution of counsel. I just don't have another attorney that I can appoint that would not inordinately delay the appellate process in this case.
Yes, sir. I understand. I just wanted to make sure I filed it, make sure I do what I.
You did exactly what you're required to do, and I appreciate your forthrightness. But and Mr. Powell, you understand what I'm doing is what I think I have to do to try to preserve your right of appeal, to make sure that it's not dismissed because you haven't done something. Mr. Stover can make sure that those transcripts are done correctly, and then you and he can talk about this appeal and what's being raised. But I'm going to deny his motion to withdraw and order that he ensure that the Court of Criminal Appeals opinion regarding the transcripts be complied with.
And you want me to draft that order? And
Yes, please. Yes. Yes, and I just want to make sure that the order reflects that I don't find that there is an ethical basis for that you would be required to withdraw from the case, and that I have no other option to appoint another attorney that would handle this case, that knows more about the case than you do, and that for that reason, I don't think it's appropriate to allow you to withdraw.
Thank you.
Thank you. General Allen,
Yes, sir.
what were you able to find out?
We are good to go for 14th. And
Well, the Corbett Miller, we need to notify Mr. Miller that due to an issue of scheduling, that there is a need to reset his trials. We're only going to move it from Tuesday to Thursday, the 14th.
I will call and let you know.
Right.
And I'll let the court know if I'm unable.
So we'll have the trial on Thursday, the 14th, instead of tomorrow. All right. Now I have no idea where I was. We still have we have anybody over here in the box that's ready on the second.
Kaiser, we just took him into custody.
All right, Mr. Kaiser, Robert Kaiser. Kaiser, do you have a lawyer? All right. This
How's
is
it gonna be a problem? It's been a problem with all the lawyers out there.
well, you have here today, you have a charge of possession of a weapon by a convicted felon. You have driving on a revoked license, possession of drug paraphernalia, violation of seatbelt law, and then you also have a motion to revoke your bond on those cases based upon the fact that the state alleges that your bond should be revoked.
Why? Why should my bond be revoked?
Because there's a state statute that says under 4011-143 of the Tennessee Code, anyone who is released on bond for a criminal offense and therefore and subsequently is arrested on a new criminal offense can have their bond revoked. So what this alleges is that on July the 3rd, you were arrested for evading arrest, Class E felony in Stewart County, Tennessee. And on July the 3rd, you were arrested for use of an OHV on a highway. And you were on bond for possession of a weapon, as I stated what your pending charges were. So as a result, the state is asking that I revoke your bond. Why was Mr. Kaiser taken into custody today?
The last two charges you just read off, sir.
Oh. So,
Those were on July 4th from the warrant for that.
and you have new charges that you've just been arrested on.
No, those are the same charges that you read off.
Well, these are new charges that you've just been arrested on, if I understand correctly. And those charges include possession of marijuana, possession of drug paraphernalia, revoked license, registration violation, and theft. And then a second indictment.
No, sir.
Pardon?
I hadn't been arrested on this, what's marijuana and
This
all that.
alleges that you and Samantha Kaiser.
No, sir. Sorry. I'm already in trial for that.
Is this just out of a recent grand jury?
No, that one next time, I think. Those all go together, so what you just read.
Like last month. I guess he's just been served on. Okay. Yeah, I don't.
All that goes
The
together.
charges that he's in custody today for is out of general sessions. Those
Oh,
are
he's been
pending
taken into custody on general session.
These charges that you have in your hand are set for status.
It looks like the warrants that the motion to revoke off of were sworn out on July, but not served until this very morning, Your Honor. So General Woodall did subpoena the officer, but the state will just ask the court to take judicial notice of the new charges.
Well, I see that It appears that he had an attorney appointed for him and that attorney was allowed to withdraw by Judge Wallace.
Yes, sir.
And was he not appointed another attorney when he was allowed to? Why not?
I think it's. I don't know. There was just that or.
Oh, I can tell you, I can explain the issue.
Explain it to me.
Well, the issue is, I have a problem with the way the officer handled it. So when I write stuff against the officer, the lawyer step down, it's not nothing personal. It's just they say they can't go against the police department in Stewart County. Every lawyer I've had to withdraw. That's what it was, not because this and that. It's because I asked for something to be done and he tells me he's not gonna do it, so we couldn't, I can't have nobody tell me like that. So he steps down because I wrote paperwork against Officer Josh Miller. Which nobody knows where that paperwork is at either.
You're in custody at the present time and you've already had an attorney appointed for you that's now been allowed to withdraw. So I'm going to do some research about what attorney I can find that can be appointed to represent you. So I need you to just have a seat in the box.
Can I say something about those, the arrests that you said that I'm in custody for today? Well, when I was in custody at this jail on July 3rd. They took me to Paris, Tennessee, which the incident happened in Houston County. But Stewart County is the one who got me to this jail, arrested me, and then sent me to Paris, Tennessee hospital for a day and a half, maybe, 2 days. And then come over and told me that I wasn't under arrest. I didn't have no arrest. So then, after I get out of the hospital, I called down here to make a complaint about the way I was treated. And then they told me I do have a warrant arrest. But they released me from the hospital, I guess because they didn't want the bail or whatever, but either they arrested me on the 3rd, and this was taken care of because I was in custody down here at this jail until EMS got here, or they took me against my will. I mean, one way or the other, I didn't ask to go to Paris. They left me in Paris. They picked me up in Houston County. They got me off in Paris. Get home how I gotta get home. With no phone calls, no nothing. With probably, well, I'm a medical record show how messed up and stuff, but that's all I'm saying.
Well,
I don't understand why this is even going on. Because that's my job. I work with small engines. State law says I can ride that on the highway, cross the 2-lane highway at a 90-degree angle.
Well, you're arguing the merits of your case, which I'm not paying any attention to anything you're saying right now. So if you want to just stand there and talk, you can do that, but you're just wasting your time and my time. I'm trying to explain to you that you have the right to an attorney. You're in custody right now. The state has requested to revoke your bond. I'm trying to find a lawyer that I can appoint to represent you because you've had counsel appointed and they've been allowed to withdraw. I need to find a lawyer who can represent you because you've got cases pending and we're going to deal with those. But I need first and foremost for you to have a seat and let me find a lawyer that I think can represent you. Okay.
All right.
All right.
Thank you.
Just have a seat. We'll come back to you. This is Monday, right?
Yes. Give me more apparent about.
Hmm. We have a 2020 CR 104 that I skipped over on page 4, but that shows that that person is at large. I assume she's still at large. Melissa M. Holloway. Good morning.
We are asking for exoneration under the pretense that last time we was here, we said we would revisit this.
I'm sorry.
We would revisit this. And you gave me an extension, and she was in San Bernardino, California. She was in the courthouse there, and they would not hold her or pick her up because it said it was unextradited. So, kind of let me stand it. If you had it.
Well, it's a felony possession of methamphetamine with intent to sell, simple possession, and unlawful drug paraphernalia. And at this point, I granted you an extension until August the 7th, and there's not been a formal motion for exoneration filed, has there?
We have. I'm not still here.
When was this filed? When was it filed? We don't have it in the court file, so I can tell you it hasn't been filed, at least as far as the court file shows. The fact that she was in California and then, let me hand that back to you. The fact that she was in California and in a courthouse and then they didn't hold her.
Correct.
But was she never in custody of the sheriff of the?
She was arrested, yes. She was.
I think for an exoneration, I've got to have proof given in the record that she was in the custody of the law enforcement.
She was arrested on this month. She was arrested and released. Then after that, she had court for us.
Well, the fact that she was arrested, but was she actually taken into custody and then a hold put upon her?
They would not put a hold upon her because once they called Stewart County said, I guess it was too far to pick her up. And it was unextraditable, is what they said.
Well, at this point, I'm going to reset your request, or I'm going to give you an extension until the December the 8th. And the reason I'm doing that is I want to look at the statute that we're now operating under regarding an exoneration, because if she was just arrested in another state and there was no hold put upon her, then I will have to determine whether or not there is a basis for the exoneration. And I'll certainly give you until December the 8th to continue to try to locate her.
That'll be fine, Your Honor. I do appreciate it. So.
That's all. Thank you. Parks, were you ready on your second call? Going back to 2020 CR 83, State versus Stephen J. Jowell.
Yes, Your Honor, the state's gonna move to Nolly this case. It was an old case, and Mr. Dowell flew down here, or drove down here from Michigan. He has shown proof that he was his life for the better. It's an older case, so since he's,
Where's he live now?
Michigan.
this is one we talked to Your Honor about.
So we're banishing him from the realm.
We are, yes.
So we're nulling the case with the hope that he never sets foot in Tennessee again.
Or if he does, it's just for a good chair.
All right. Case is dismissed.
Thanks, sir.
Twenty 24 CR 60, State versus Daniel Franklin Phillip. Clemens?
Yes, Your Honor. We have some video on that one.
All right, I've been handed a document indicating that Mr. Phillips is going to be entering, pardon me, a plea of guilty to count 1, simple possession of methamphetamine, a class A misdemeanor. Counts 2, 3, and would be dismissed, as well as 2024 CR 60. He would receive a sentence of 11 months, 29 days, suspended to supervised probation after served 30 days in jail, $750 fine at cost. The waive court costs.
Yes, Your Honor. We'll pay the fine.
Complete an alcohol and drug assessment, follow treatment recommendations. Jail can be served on consecutive weekends beginning September the 5th. Raise your right hand, Mr. Phillips.
You solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God. Sir, thank you.
State your, turn that microphone towards Mr. Phillips. State your full name for the record.
Daniel Franklin Phillips.
Mr. Phillips, you're here today charged with a multi-count indictment. Actually, 2 different indictments have been indicating you're going to plead guilty to 1 charge and the rest are all going to be dismissed. But have you seen or been shown a copy of the charges? Talk them over with Mr. Clemens and feel like you understand the charges against you and the range of punishment you're facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand if you went to a trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of a crime. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena. Do you understand that that if you went to trial, you would be presumed to be innocent and you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial? You understand that if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyer has worked out. You understand that's going to result in a misdemeanor conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath and on the record, and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we were to find that you had lied under oath. Is your decision to plead guilty today voluntary? Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied you are in fact guilty of these charges and that there are facts to support it. Are you in fact guilty of this simple possession of methamphetamine? That kind of speaks for itself, but you were in possession of an amount of a small amount of methamphetamine? All right. Anything further that you feel like is necessary from the state?
No, Your Honor.
All right. Are you satisfied with your attorney services?
Yes, sir.
Feel like that Mr. Clemens has done a good job of representing you competently.
Sir.
Mr. Clemens, you know of any reason you should not enter this plea?
No, Your Honor.
Then Daniel Phillips, in this case, you are found guilty of simple possession of a methamphetamine and sentenced to 11 months and 29 days in the county jail. That will be suspended to supervised probation after serving 30 days in jail on consecutive weekends beginning September the 5th, 2025. You ordered to pay a $750 fine. You are also, as a condition of your probation, ordered to complete an alcohol and drug assessment, follow all treatment recommendations. Counts 2 and 3 of this indictment are dismissed along with 2024 CR 60. He needs to see the probation officer before he leaves.
Yes, Your Honor.
Are you ready on Jason William Phipps, Mr. Clemens, the inmate?
I would like to chase some talk.
All right, I knew we had on second call, so I'll pass it.
Thank you, Your Honor. I do have an announcement.
All right. April Smithia.
Your Honor, for Ms. Smithia, she's charged with a violation of probation. Today, the intention is to admit to the violation of probation, agree to state, extend probation for an additional year, and be required as a condition to complete an alcohol and drug assessment and comply with any recommendations thereof.
All right, so she's going to admit her violation, be revoked to serve the sentence, but reinstated on time served and extended for an additional 1 year period. And as an additional condition of her probation, she would have to undergo alcohol and drug assessment, follow treatment recommendation.
Yes, Your Honor.
All right. Ms. Smithia, raise your right hand. Let's place you on the road.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
State your full name for the record.
Renee Smithia.
Ms. Smithia, you are here today charged with probation violation. Do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, Your Honor.
You understand that if we had that hearing, you would have the right to have a lawyer and have one appointed. Of course, we've done that with the public defender.
Yes, Your Honor.
You understand that if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of guilty, you're waiving your right to a hearing and to an appeal. All I'm going to do is prove what the lawyer's worked out. You understand that?
Yes.
Do you wish to plead guilty and waive your right to the hearing and to the appeal?
Yes, sir.
Then upon your plea, I found you guilty of violating your probation or that you be revoked to serve your sentence, but by agreement with the state and on time served, you're reinstated to probation and extended for a period of 1 year. As an additional condition of your probation, you're required to undergo an alcohol and drug assessment and follow the treatment recommendations. If you don't do that, then that's a violation that will send you back to jail. Do you understand that?
Yes, Your Honor.
Oh, thank you. Good luck. All right. Well, that 2025 CR 34 State versus Wesley Joe Price. Mr. Clemens.
Yes, Your Honor. Mr. Price, on up.
Should be being arraigned on superseding indictment. We'd like to set this for plea
In December. But, so this is for arraignment on a superseding indictment. Do you wish a formal reading of that indictment?
No, Your Honor.
Tender a copy.
Your Honor, on behalf of the defendant, acknowledge receipt of the copy. Indictment approved the reading, enter plea not guilty.
Plea not guilty is entered status on December the 8th of 2025. All right, thank you. Twenty 22, State versus Dewey Preston Robinson. Mr. Robinson, you are charged with aggravated burglary of a habitation, possession of a weapon by a convicted felon, and assault by use of threat of bodily injury. This is here today because it's a status to allow the state to allow the court to determine where we are in trial preparations. You're representing yourself, is that correct?
May have to change that though. The state sent me a DVD that I can't watch on anything. It says it's HVEC protected. I can't watch it on anything I have in my house.
He does have appointed counsel. He has a public defender in Houston County. This has a contained case set for status on the 25th this month. I think it would be easier for him and the state, honestly, if we could get him the PD here, Your Honor, and move these cases.
How did he obtain a public defender in Houston County? You have. All right. Mr. Clemens will appoint your office to represent him since your office already represents him on the other matters.
Yes.
Let's
We can go ahead and give it a trial date if you would like.
well, I mean, we'll just, there's really, that's up to you. At this point, he now has an attorney on these charges. And I don't know whether or not that's going to, I don't want to set a trial date if it's just going to be resolved. So let's put it on December the 8th for status. If you all work out an agreement between now and the later in the month in Houston County, then you can do a package deal over there.
We'll be ready for the Your Honor. Well,
All right, we'll put it on December the 8th. Yep. 2022 CR 27A, State versus Mark Carl Rowell. Mr. McAdams.
That'd be a plea.
All right.
Post-trial version.
All right, I've been handed this post-trial diversion, judicial diversion.
Yes.
And I've been handed both the certification that he is eligible. Then at this point, he is going to be entering, according to this agreement, plea of guilty to count 1 under 4035-313 to an amended charge of attempted aggravated child abuse and receive a sentence of 3 years suspended and supervised probation to have no contact with the victim. He must waive. No, he must waive the spousal privilege and testify truthfully against Stephanie Rollins. All right. He waived the spousal privilege to testify against her, or is she the one that has that privilege? That's going to be an interesting legal question. So,
but this part of this, as part of this plea deal, Your Honor.
he has to testify truthfully. I wonder about that. But anyway, Mr. Rowell, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, thank you.
Oh, thank you. State your legal name, your full legal name, please.
Carl Rowell.
Mr. Rowell, you were here today charged with, you've heard me go over what the agreement is. You understand what you're charged with, and have you and Mr. McAdams been able to discuss the range of punishment you're facing, the evidence the state has against you, and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to this amended charge of attempted aggravated child abuse. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt. to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir, I do.
Do you understand that if you went to trial, you and Mr. McAdams could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
So that means that you're going to be placed on probation under a specific statute designed for people who have no prior criminal record. And that if you successfully complete this probation of 3 years, then at the end of that time, you can have your record expunged or wiped clean as though this never occurred. Do you understand that?
I do.
But do you understand that if you violate the terms of your probation, then this will become a permanent conviction? And it could also mean that you could be brought back before the court and re-sentenced within the range of punishment for this offense. And it means you could get more time if you violate your terms of probation. Do you understand that?
I understand.
Do you understand everything I've explained to you?
I do, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea?
Yes.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath. Was your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Sir.
You understand I have to have facts to support the fact that you're guilty before I can accept your plea?
I do.
And is the state going to tell me what the facts are, or are you going to allow him to testify? Let her step aside and let her step in front of this microphone, please.
Your Honor, the state would put on proof that in April of 2020 here in Stewart County, the victim, minor Gabrielle Norton, was living with Mr. Mark and Stephanie Rao in their care. Leading up to that day, she was subject to discipline, which left bruises on her body, malnourishment, and other discipline that be categorized as psychologically damaging to a person, especially a minor, Your Honor. And Mr. Rao, while Stephanie Rao was the primary caregiver, that's the state, that's the proof that will be shown by the state. Mr. Mark Rao was also a caregiver, Your Honor, however, he worked so during the day. So he was not at home for a lot of the actions, but he also was aware of it, did report it as the stage.
Right. Mr. Rowell, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be at trial?
I do.
Do you understand that it's also a requirement of this case that you testify truthfully if you're required to testify at a future trial for any other person?
Yes, sir.
Are you satisfied with your attorney services?
Oh, yes.
Feel like Mr. McAdams has done a good job of representing you confidently?
Sir.
Mr. McAdams, you know of any reason you should not enter this plea?
No, sir.
Then Mark Rowell in docket number 2022 CR 27, upon your plea to the amended charge of aggravated child abuse, I find you guilty. Sentence. Well, actually, I place you on probation for a period of 3 years under 4035-313. That will be supervised probation. You're to have no contact with the victim in this case, and you must waive any spousal privilege and testify truthfully against Stephanie Rowell. All right. He'll need to see the probation. Twenty 2025-031B, State versus Benjamin Sasag.
What page is that? I'm sorry.
It's on page 9. Benjamin Sosag.
I must have just stepped out here. I see his hat still out here on the bench.
Morning.
In the restroom.
We'll come back to it.
Thank you.
Twenty 2023 CR 103, State versus Billy Russell Tomlinson.
I'm attorney for Mr. Tomlinson. He is unfortunately incarcerated in Coffee County. And been serving some time there. I've heard maybe out of want to ask if we could reset this. Some other things going on with the case too, but that's the big one.
The state doesn't oppose for setting it, Your Honor. It's also, I think the constitutionality of the homeowners improvement fraud statute is on appeal. Is that right?
Is it my case?
I don't.
I don't know. I have one, but it got appealed. I did a bench trial on
Oh,
it.
your case is being appealed. I don't know.
And my case got already heard, and the Court of Criminal Appeals said that they defined that even though I found the defendant guilty of this violation, they found that it was not, in fact, a violation. It was a civil matter, so they vacated my decision. So I don't like bench trials. So you want to set this for December the 8th?
Just so we can track it, Your Honor.
Oh, December 8th.
Thank
you. Ms. Pascal, are you ready on Jessica Watson?
Yes, Rob. So the very last court date that I was present was July 28th. At that time, I announced to Judge Combo that we would be resetting today for a VOP hearing. My client had just been picked up in Montgomery County and she was not here. So I am requesting the violation probation hearing today.
Are you ready on the violation of probation hearing?
We can, Your Honor. She needs to speak that Mr. Potter's here.
Just, I'm not prepared today. Just for arraignment.
Well, it is for arraignment, and typically what would happen unless there's an agreement to resolve the case, we would just simply set it for the next VOP, which is next month. So
I did have an agreement with DA with all to reset today for VOP hearing. So, I mean, I did have that agreement. We announced it to the court. So I would prefer to move on today.
Mr. Potter's not ready, Your Honor. I'm gonna.
I'm not, Ms. Pascal, I'm not disputing what you understood your agreement was, but the docket entry shows that the defendant was not present and that you were here and announced that the defendant was in the Montgomery County Jail and requested to reset and transport. And then Judge Turnbow reset it for today to issue a transport order.
Yes, Your Honor.
So based on the fact that this is only here for arraignment according to our court records, not disputing that you have that agreement, I'm going to reset it for next month. What is your next date?
Your Honor, due to that, my client may want to switch admits as to what she needs to do today. So
Well, talk to her and let me know, but what the next court date would be for VOP. September 8th would be your next date, a little less than 30 days away. So talk to your client, and depending on what she wants to do, we'll either give her that date or come back to her. So, thank you. Are there any second calls that we can take care of?
If I may, Your Honor.
All right.
Program.
This is on the superseding indictment arraignment.
Yes, I believe there's a.
Here you go, Doug.
Yes, Your Honor, we would waive formal reading of that, enter a plea of not guilty.
Plea of not guilty is entered. It does not show that this was a superseding indictment, so it don't show that there was a trial date already. Is that correct?
And there is a co-defendant that we have not been able to locate. Not even citizens of the country, but again, investigator Etheridge Senior, Dad Etheridge on that. And we just asked for another status date of 12/8.
All right, we'll set it for December the 8th,
Thank you, Your Honor.
2025.
That's all the business I have today. With the rest of the day.
All right, thank you. Clemens?
Your Honor, on page 4, we have the case of Gayla Rice, Ms. Rice. Is the case for Mr. David Bell. This case was standing again today. wanted to add. That's
Okay. We'll set it for December the 8th. That'll be the last status date that we'll give. It'll either be resolved on that date or set for trial.
Your Honor, just for the record, I do believe we have it resolved, but Mr. Walker now works for the state, so that's gonna have to be an issue that.
He now works for the state.
Prosecutor in
Okay.
Easton. So I think we might have to do something.
All right. Okay. We'll set it December 8th. And all right, we've gone through the docket and we'll take a recess this morning and allow anything else that we need to get any of the other inmates brought over that we're ready for. Because I think everybody else on the docket is an inmate. I need to check on the attorney status as well for that. All right. We'll take a short recess, 15 minutes, I'm sorry.
All right.
Are we ready on any of the other inmates that we have? All right.
no, case of Dawson Rory.
Dawson Rory on page 9. Violation of probation.
Your Honor, we had been in the middle of agreeing to a violation of that probation and have paused it. We want to proceed with the violation of probation. As Your Honor was understanding, Your Honor would have understood this is requiring this version be revoked, or would have the effect of having the version be revoked. Discuss that state, my client, everybody's agreeable to proceed with that understanding.
Right, so we are basically going to do what you had agreed upon, but this judicial diversion is revoked.
Exactly.
All right. Then I think I've already gone through all of, go ahead, you need to talk to him.
No, it was just making sure it is, he's going to be reinstated in probation, extended for a year. It's going to be required to complete an alcohol and drug assessment. As part of that, apply with the recommendation set for the major judicial grad.
Right. I don't know how far I got, but let me just kind of recap everything real quickly for you. You understand you have a right to plead not guilty, and you have a right to a hearing where the state would be required to prove to the legal standard that you have violated your probation. You have the right to a lawyer, and if you couldn't afford one, we'd appoint one for you. You understand all that? You understand that if we had the hearing and I found you guilty, you could appeal what I did and have a court appoint a lawyer to help you with that appeal.
Yes, Your Honor.
You understand that by pleading guilty, you're waiving your right to that hearing. And I was the one who brought up the fact that you were on judicial diversion, which is basically a person in the first offender status that now that you have violated your probation, in my opinion, that would not be justified to allow that to remain. And it's my understanding that you understand that and you want to go forward with this plea.
Yes, sir.
All right, then upon your plea of guilty to the charge of violation of probation, order that you be revoked. But on time served and with the agreement of the state, you'll be reinstated to active probation and extended for a period of 1 year. You'll be also required as an additional requirement to undergo an alcohol and drug assessment and follow any treatment recommendations. Okay. You're a young man, try to make sure you make this could be your last chance to avoid going to prison. Okay.
Yes, Your Honor. Thank you.
Good luck to you.
Thank you.
And Your Honor, Mr. Phipps is the remaining inmate. That's going to be for a hearing as to disposition of the appeal.
All right. I've got inmates at the jail that I need to try to go ahead and deal with, and then we'll come back to Mr. Phipps. At the jail then, do we have anybody there at the jail that can bring up the first inmate?
Yes, sir. Can you hear us?
I can. Thank you. Good morning. What is your name?
No, I think what I'm ready to.
All right. Motion to revoke bond and for an arraignment. You're here to be arraigned on a number of different indictments charging you with being a caregiver and neglecting a vulnerable adult, possession of methamphetamine, possession of drug paraphernalia, possession without a prescription. Then you also have a second indictment charging you with methamphetamine, possession with intent to sell. Again, another count of neglecting a vulnerable adult, violation of a condition of release, violation of the possession of a drug paraphernalia, driving while in possession of methamphetamine, resisting a stop, and some other traffic offenses. Then you also have a third indictment charging you with giving false report to a police officer and violating a condition of release. And then all of these, you're entitled to an attorney to represent you. Do you wish to have a lawyer represent you?
Yes.
Public defender have any problem in representing this lady?
I don't think so. You're right. May I ask, I don't remember this case in general sessions. Know the victim?
Had you been previously arrested and gone through the general sessions level?
What is this?
What I'm asking is, were you,
I didn't.
I don't think there'd be any conflict.
do what? We're going to appoint the public defender to represent you, and the assistant public defender is here, and he is going to receive a copy of the indictments in your cases. Clemens, you wish a formal reading of any of those?
No, Your Honor.
Carmen, can we put this for November 10th? This is going to be General Goodall's case.
No,
All right. We'll reset it for November the 10th for status. And you had a motion to revoke bond. Is that necessary to argue today?
Okay.
All right. All of your cases are going to be set for November the 10th, and we have given you a lawyer with the public defender's office. Mr. Clemens will be up to speak with you as quickly as he's able to arrange it.
Thank you.
Thank you, ma'am. You just have a seat. Your lawyer will be up to talk.
Thank you.
All right, next inmate.
Seth Cole.
Cole, you are believed represented by the public defender.
We have settlement ready in these cases, Your Honor.
You want to have him brought over, or you want to do it by Zoom?
Bring him up, please, Your Honor.
We need to have him brought over. We're going to bring you over for disposition in your case, okay?
Sir, see you later.
Okay.
Mr. Duncan, you have a pro se motion for a furlough to a rehabilitation center.
Yes, Your Honor.
So in April of this year, you appeared before me and you admitted your violation of probation, and you were revoked to serve the balance of your sentence.
Yes, Your Honor.
And you have asked for a furlough to go to Safe Harbor Rehab Center.
Yes, Your Honor.
Have you already been admitted, and have you applied and been admitted to Safe Harbor?
I applied and I had a set letter.
You have applied and what?
I received a acceptance letter and I sent it to Wayne Clemens.
So you have not if I'm understanding it, it sounds like you're kind of breaking up to my end. But you have applied, but you have not been accepted, correct?
No, Your Honor, I have been accepted. I think I sent this letter to Wayne Clemens.
State have any position about this?
He's been sent, but.
He's right, Your Honor. I checked and I have received an acceptance letter. He's
He was, he entered or was found guilty in May of 29th of 2024, sentenced to 2 years. And then he was charged with violation of probation because he was arrested on some charges in Montgomery County. What is the status of your charges in Montgomery County? Have those been resolved?
This Friday, I have a court session for circuit court in Montgomery County, and I'm getting time served. I'm currently on OR bond.
You're on an OR bond out of Montgomery County
Yes, Your Honor.
on a charge of theft, simple possession, unlawful drug paraphernalia, criminal impersonation, prohibited weapons, evading arrest, and theft of merchandise. All of those occurred on November the 24th of 2024.
Yes, Your Honor.
And you are scheduled to be in court over there. Those cases are still pending, correct?
Yes, Your Honor.
Well, I can't grant you a furlough to go to safe harbor when you have pending charges in Montgomery County, because I'm not going to order your release from our custody until those cases are resolved. So you're going to have to resolve your Montgomery County cases, and then I'll consider whether or not I or one of the other judges can consider giving you a furlough once we see what happens in those cases. But with pending charges against you, I will not issue a furlough to you though on our charges. You understand that?
Yes, Your Honor.
Get your cases in Montgomery County resolved, and we'll take a look at you again, okay?
Thank you, Your Honor. I'm going to Thursday.
What's your name?
Dakota Edie.
Dakota, what?
Dakota, on page 3. Edie, you're here to be arraigned on a charge of probation violation. You have the right to an attorney to represent you. Do you wish to have a lawyer?
Yes, sir.
Public defender will be appointed. So, wish a formal reading of that?
No, Your Honor. No, on behalf of the defendant, officer, copy of the affidavit, waive reading, enter plea not guilty.
Plea not guilty is entered. What's the next deal, Peter? We'll reset your case for September the 8th for hearing, and your lawyer will be up to talk with you as quickly as he's able.
Your Honor, is there any way I could possibly get a bond by chance?
Not without a hearing, based on the, violation of probation case. It's not the same as when you have a charge that you're presumed to be innocent. You've been found guilty of a criminal case, and so the idea that you're entitled automatically to a bond is not necessarily applicable. You are charged with driving under the influence of an intoxicant, 3 counts, and vehicular assault, and as a result, you've got a sentence of 3 years back on May the 13th of 2024. The allegations are that you violated your probation by being arrested on or about
In another county. My time is done for that county as well. All my stuff's taken care of in that other county. The only thing I have to deal with is what I got here.
I've appointed you a lawyer, and I'm going to let your lawyer talk to you, and he'll let you know whether or not he can set a bond hearing. So. All right, next inmate.
Christopher Poston.
He needs to go.
Posted here to be arraigned on the charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
All right. Public defender will be appointed.
Here on behalf of the defendant, acknowledge receipt of the copy of the affidavit, waive reading, and you're not guilty.
Plea of not guilty is entered. Set for hearing September the 8th. What is your name?
Nathaniel Taylor.
Page 10. Taylor, you're here to be arraigned on the charge of driving under the influence of an intoxicant, open container, and then your lawyers have filed a motion for relief from your bond. First thing I want to deal with is to arraign you on these charges. Do you wish to have a lawyer represent you on these charges?
Yes, I have a lawyer. And you said my lawyer filed a motion for what?
Well, your bonding company has filed a motion to be relieved from your bond because of the fact that you have missed a court date, and they're asking for us to be allowed, or them to be allowed to be released from your bond because you missed a court date.
Yes, sir. If it's any consolation, can I speak?
I'm sorry, if it's any consolation, what?
Do you mind if I speak?
No, go ahead.
I did call about my court date. I've never been to circuit court. I called a month beforehand and I was under the misunderstanding. She told me to call back the 18th. I talked to Miranda at the clerk and she told me whenever I showed up for probation on the 16th, she informed me that I was supposed to call on the 8th. And I missed my arraignment on the 14th. So I went upstairs on the 16th. She told me a capias had been written out, but the judge hadn't signed it yet. She said she'd come back on the 28th at 1 o'clock. I showed up for court on the 28th at 1 o'clock. Apparently my court date was at 9 o'clock in the morning. And the warrant hadn't been signed. I did show up for court on the 28th. And you can ask Miranda. I did go up there and talk to her on the 16th. And I mean, it was just a big misunderstanding, I reckon. And I've been to court 10 times.
Who is your lawyer?
Wayne Clemens.
Who is it?
Wayne Clemens.
Wade Clemens. You
Yes.
represent him, Mr. Clemens?
In general sessions, I was involved with you.
When I was in general sessions.
And so it's my understanding, Mr. Clemens, you're moving to set aside the conditional forfeiture of his bond and reinstate his original bond? Say yes.
Yes, yes, Ron.
All right, I find that there is an excusable reason why he missed his court date, and therefore I'm going to set aside the conditional forfeiture of his bond, reinstate his original bond. Now, Mr. Taylor, I'm giving you the benefit of the doubt that you had an honest issue that you failed to appear. So I'm reinstating your bond with Freebird Bonding. That means you have to do everything you're supposed to do. You need to stay in touch with your bonding company, let them know where you are. And you have to make sure you stay in touch with Mr. Clemens and make sure that you're ready for your case to be heard. We're going to set you for, it shows he's for arraignment, so he hasn't actually been arraigned. I'm going to go ahead and arraign him give you a copy of that charge.
Yes, Your Honor.
Thank you, sir.
Yes, Your Honor, I have, the defendant now received a copy, indictment, waive reading, enter plea of not guilty.
Plea of not guilty is entered. You want to set it for status in the December date or an earlier date?
12/8, Your Honor. Mr.
All right,
Clements,
we're gonna set it for December the 8th. Now, you missed another court date, and I'm gonna figure out that you were not truthful with me about the situation, and I don't mind people, stretching the truth a little bit, but you outright lie to me about it, and I'm gonna take punitive action. So you be here and stay in touch with Mr. Clemens. So you're raising your hand. You something else you want to say?
Yes, sir. I didn't know how circuit court worked. General sessions, I had 10 court dates before I went to circuit. I never missed one. So it was a big misunderstanding. It won't happen again.
You understand that I'm accepting your explanation, reinstating your bonds, so you don't have to explain it anymore. What I want you to understand is that you're right. Circuit court doesn't operate the same as general sessions court. In this court, you have a lawyer, and it's your obligation to stay in touch with him and to make sure you know when your court date is. If you miss another court date, then you're going to be held without bond. Okay?
Yes, sir. I thank you much.
All right.
Does that mean I'm getting released today?
It should, unless you've got some other charge pending, because I have set aside the revocation of your bond and reinstated your original bond, so they should release you.
Thank you, sir.
How long have you been in jail?
15 days today.
Well, it sure seems to me like if he's a DUI first offense and he's been in jail 15 days, which is 13 days longer than the minimum on a first offense DUI, it would seem to me that that might be something that could be resolved. But you want to have him brought over after lunch to try to see if you can resolve it? Or do you want to just?
He's being released today, I believe, and
yes,
I would prefer to simply leave it.
That's fine.
It's
We're going to release you today, but you stay in touch with Mr. Clemens, okay?
Yes, sir.
All right, thank you.
Thank you.
What's your name?
Levi Thomas.
Page 10. Mr. Thomas, you're represented by Sherry Phillips, but we have a petition here from your bonding company asking to be relieved from your bond based on the fact.
Your Honor. Is there any way I can speak to Miss Sherry Phillips? I've yet to be able to talk to her, or she has yet to talk to me.
Was she appointed to represent you?
Yes, this was last month, Your Honor.
But only recently, only on the 29th, that's why she.
Well, I have on there. Is she basing on her practice?
I think she's trying to retire, graduate. I know.
When Wayne Clemens had represented me, there was supposed to have a deal from the DA last month, and I missed my court date. Or the state or something.
For some reason, your office can't represent him now?
Yes, Your Honor, a conflict that arisen since the last court date.
And what is the conflict that has arisen?
There was an incident with an inmate that when I was out and I was acquitted of the charges.
He shot.
But dang, Wayne. My bad, Your Honor.
Sometimes it's better just to be quiet for a few minutes and let us sort through things. She filed a motion to. Well, let me say this. Your lawyer has filed a motion for discovery that in your case, so I think she is working on it. I'm going to suggest that you will send a message through the clerk's office that you're requesting to talk to her and to try to let her know that she needs to get in touch with you so that you can talk to her. Okay?
I've tried to contact her. Her phone is not toll free or an attorney phone number, so I can't call her at all. I've tried ways to contact her. Is unknown.
So she has filed a motion for discovery with this court.
Is there any way that I was trying to resolve this matter? Because I'm trying to resolve this matter as quickly as possible, Your Honor. Is there anyone
Well, you're
that,
charged with felony, so I can only tell you that I cannot really allow you to represent yourself when you've got an attorney appointed. Let's relieve Ms. Phillips as the attorney of record. I'll appoint Lindsay York of the Dixon County Bar to represent this gentleman. I'm going to give you a different attorney. This attorney is out of Dixon County, and she is going to be able to probably get in touch with you a little quicker than Ms. Phillips. Ms. Phillips is kind of winding down her practice, so I think it'd be better if we could get you with a different attorney.
yes, sir.
So I'm going to appoint someone named Lindsay York, and she'll be in touch with you, okay?
All right, is there a phone number I can get for her? Or
Don't have her phone number, but she'll be in touch with you. And you can get her, she's with the Olin Baker Law Firm out of Charlotte, Tennessee. Okay?
All right,
All right, thank you.
next court date?
Pardon?
Is there another court date that I need to look for?
Yes, September his status is set for November the 10th, so your next court date is November the 10th. And then we have a petition for exoneration filed by you see that file one, so. Your probation, I'm sorry, your bonding company is filed asking to be relieved from your bond. So in July of 2025, he was not present, and that's when the judge issued a capias for his arrest.
You said when?
And he was in custody and present for court back in July 28th. There is a statute that says that when you miss a court date and you are then later taken into custody, that the bonding company that had your bond has a right to request to be relieved from your bond because there was what they call a surreptatia issued, an order issued to the bonding company that they had to bring you into custody or pay the bond. And your bonding company is now asking for relief from that. Is that correct?
Correct.
Right. You'll have to make another bond since you missed your court date, and I'm allowing the bonding company to be released.
Thank you, Your Honor.
Your lawyer can help you with that, but right now, you just need to make sure you are able to talk to your lawyer as quickly as possible.
Yes, Your Honor. So I have a bail set.
I'm sorry?
I have a bond.
Your bond is the same, but you do not, I mean, the amount of the bond is the same, but you'll have to make a new bond to be released.
Yes, Your Honor.
Okay. All right. We have anybody else there?
Your Honor, we do have one more that's gonna have to be brought up separately. She should be on her way now, though. So I'm ready.
And what's the name of the?
Tamara Ingram.
Okay.
Case of Tamara Ingram is set for a status today. We're awaiting a competency evaluation that hasn't been completed yet, and that's all. So
So we don't need her. We don't need this. Her lawyer just advised that we're waiting on a competency evaluation for her, and therefore we do not need her, so.
Yes, sir.
All right.
That would be it from our end, sir.
All right, thank you. We have a couple,
Thank you.
or at least one that we're gonna bring brought over.
Since we put Tamara Ingram on the 10-6 docket.
Oh.
Thank you.
it's right. That's
10-6.
Yes, sir.
All right.
We've got 2 or 3 inmates.
Hmm?
3 inmates.
You have 2 or 3 inmates left.
This client coming up.
Mr. Bonenberger, what do you have?
I have a, Mr. Nixon, he has filed a motion for a bond.
Is he in custody? Well, we need to have him brought over, and then we'll have a hearing on that. Okay. So we have that one, and then are there any of these folks that we have? When did you have an individual that you were requesting to have brought over?
Yes, Your Honor. Today is Mr. Hines. Here for a settlement. Have ready to announce.
What is your agreement?
Your Honor, in these cases, he's charged with violating the terms of his probation. He agreed to admit to the violation of probation. Waive hearing, reinstate the probation, have it extended for 2 years. Prior to complete rehabilitation as a condition of probation, which he would intend to start, I believe, today. Is that correct? We have him approved. His intention is basically leave from here straight there.
All right. Have you, so we're basically, we don't have a plea agreement, sheet.
Not written, Your Honor.
All right, that's fine, but just to make sure, then he's admitting his probation violation, and the agreement is that he would be reinstated with the additional condition of entering into a rehabilitation program and successfully completing that.
Yes, sir.
Is there any extension of his probation?
For 2 years.
2 years.
Yes, sir.
All right. Mr. Hines, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
State your full name for the record.
James Aaron Richard Hines.
Mr. Hines, you're here today on a probation violation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed, as I've done with the public defender?
Sure.
You understand that if you had that hearing and I found you guilty, you could appeal my judgment and my ruling to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Sure.
You understand that by entering this plea, you're waiving your right to a hearing and to an appeal. All I'm going to do is approve what your lawyers worked out.
Sure.
That's going to mean that you're going to be required to go into, you're going to be reinstated in probation, but required to go into a rehabilitation program and successfully completed. And it's extending your probation for 2 years. Do you understand all of that?
Sure.
Is that what you want to do?
Yes, sir.
And by pleading guilty. And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but reinstate you by agreement with the state on time served, in order that you be, as an additional condition of your probation, required to enter into and successfully complete a rehabilitation program, long-term inpatient rehabilitation program, and your probation is extended for a period of 2 years. All right. Good luck to you.
Thank you.
Ms. Pascal, what did you decide about you and your client's case?
We'll agree to reset to September 8th for evaluation. probation hearing.
So September the eighth, correct? All right. Then that was the State versus Jessica Watson will reset for September the eighth. Thank you. All right. Ms. Pascal, what I see you on here? Then we have to have people accept appointments. Would you be willing to take an appointment? What time? Okay. So,
But I would be, the cases are settled. But as a private, I'm judge. So
okay. So understand that we wouldn't put you in a position where it's not a problem, but we'll just keep it something quick.
it's something quick, but March, you know,
All right. So good luck to you.
I'll be out. Thank you, Your Honor.
Now, Mr. Bonenberger, do you have your client here? This is a pro se motion for a bond reduction.
Yes, Your Honor. Well, actually, just to set a bond, Your Honor. And he'd like a reduction on the other ones. There have been additional charges that I have just been appointed to, other than the original charge that I was appointed to. I received notification of that on the 20 of the new charges on the 29th of last month. We are anticipating I think we've got this set for a settlement date on the 8th of September and then trial on the 10th. I'm going to endeavor to be ready for trial on the new charges at that time. I haven't gotten all discovery on the new charges, so I don't know whether that's going to be true, but that is what we are working towards diligently. What we are asking for is on his current charge, he has no bond, and we would like to set a bond on that and overall.
So what is the current charge that there is no bond?
First offense DUI. We settled for jury trial and the attorney recused herself the day before trial. It's a farce and a sham.
Mr. Nixon, let me speak. Yeah, anything you can say can be interpreted against you. It is a first offense DUI, Your Honor.
I prove it right now.
You are certainly.
All right. According to the docket, there was a motion to revoke bond, and I granted the motion to revoke bond in April of this year. And a request for a speedy trial by the defendant that a trial date was set of May 13th of 2025. Then there was a motion to withdraw filed by his attorney, Crystal Wilkinson. And then on May the 12th, the day before his trial date, she argued her motion to withdraw, and Judge Wallace granted that motion and appointed attorney Adrian Bonenberger to represent him and set a new plea date of September the 8th of 2025 and a new trial date of September the 10th of 2025. So that's where we are on that case. And the motion to revoke bond that I previously heard was based upon
Charges. He's a good judge.
So that was clear. The motion to revoke bond that was filed in February of this year and that I heard in April alleged that you were placed on probation or not on probation, but you were arrested for simple possession on February the 21st of 2025, and that you made bond, that you on February the 21st, you were also arrested for simple possession or casual exchange and driving under the influence of an intoxicant, possession of unlawful drug paraphernalia. All of these were on February the 21st. And that you were also arrested for violation of conditional bond, reckless driving, failure to exercise due care, no driver's license, violation of the seatbelt law, and driving under the influence, while you were on bond for driving under the influence at the time, and that's why the state requested that the bond be revoked. And I think I explained at that time that there is a statute that says the person who is charged with an offense and on bond for an offense, and then is arrested on additional offenses, that the court has the power to revoke the bond and hold him for trial. And that's what happened back in April.
Right, so that's why I filed for the fast speedy motion trial and then, you know what I'm saying, and so forth from there. And then now I've got over 6 months, almost 7 months on a first offense DUI that, you know what I'm saying, they're not even gonna be find guilty of. You know what I mean? Like, so where's the sense of holding it with no bond on that charge? Is there sense on that charge? Is there,
Well,
trying to figure out what the sense of that would be, you know?
the purpose of holding someone for who has made bond and then had their bond revoked is to ensure that that person doesn't continue to violate the laws of the state of Tennessee and for the general protection of the public. Mr. Bonenberger has been appointed and he's graciously accepted the appointment because he does practice in our court, and he's indicated he'll be ready for your trial next month.
I think so. Trial next month, and there ain't no more delaying it or playing with it.
I have not received discovery yet, although I just got the appointment less than 2 weeks ago. I am trying diligently to be ready.
I'm sorry, I misspoke. He's trying to be sure to be ready.
I believe this man right here, yeah.
And what I'm gonna do is I'm gonna defer your motion for bond until that September the 8th date and let Judge Wallace, is that who's coming in? Let Judge Wallace.
I've had everything stolen from me. I've had my bank account's been emptied out over $7,000. My house has been totally demolished, destroyed.
Well, here's what I want to do. I want to give him, your lawyer, time to get ready for your trial. And he needs to be able to do that. If for some reason that can't be done, then Judge Wallace can consider your motion for bond to be reinstated.
Nobody else would consider it because you put it into effect.
Well, I'm putting in this order that Judge Wallace should consider your motion for bond on those cases if Mr. Bonenberger is not able to get ready for trial. And I do that because you filed a motion for speedy trial.
Greatly
And as
appreciate
a
it.
result, with a motion for speedy trial, it needs to be done as quickly as possible. Unfortunately, your other lawyer was allowed to withdraw.
Yeah.
Mr. Bonenberger is a good lawyer. He's doing everything he can to get ready for you, okay? All right, so September the 8th. Who do we have left?
Seth Cole for Plea, I believe.
All right, Seth Cole.
And I don't consider it.
Are we ready on Jason Phipps?
Yes.
Right. Just for hearing, is that correct?
Yes. This position, Your Honor, his intention is to admit the violation.
So we're gonna have a hearing. He's gonna admit the violation, but you want to be heard on sentencing.
Exactly.
All right. All right, Mr. Phipps, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
All right, state your full name for the record. Mr. Phipps, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing of this court where the state would be required to prove to the legal standard that you had actually violated your probation? You understand that you would have the right to have a lawyer and have one appointed, which we've done with the public defender. You understand that if we had that hearing and I found you guilty, you could appeal both my finding that you had violated your probation as well as the sentence that I imposed. Do you understand that? Do you understand that by pleading guilty to the charge of violation of your probation, but requesting to be heard on the sentencing, you're waiving your right to contest the issue of whether you violated your probation, but you are going to preserve your right to appeal if necessary what I do in your case if you're dissatisfied with my ruling. You understand that? You understand everything I've explained to you? Do you want to plead guilty to the charge of violation of probation with reserving your right to be heard on sentencing? Then I find you guilty of violating your probation. And if you wish to be heard, Mr. Clemens, you want him to testify?
Well, I can testify.
Come around here, please, and have a seat in the witness stand. All right. Clemens, you may ask.
Please tell us your name. Mr. Phipps, you went on probation, looks like you started off in January of 2020, about 5 years ago now. Does that sound right? All right. And you initially had a violation of your probation and had to serve a year. Correct. And that was, you got out, and when you got out, you were placed on community corrections for a while. Correct. And then, did well on community corrections, looked like, until in April, July 2022, looks like they took you off community corrections, put you on regular supervised probation. I presume that must have been you were doing all right at that time then. And during this time, who have you been living with, and what have you been doing?
Been working for Ricky Bruce Trucking Company.
I'm sorry, what trucking company?
Ricky Bruce. I work along there, they drive a camper on property, I have a camper there beside the house property, and I shouldn't have heard and even more drive. Heard or me coming and take her to.
So you live on the same property, that is, you have a camper living on the property of your mother, you say?
Probably 20, 30 feet away from the house.
And you're her primary caretaker? How old is she now?
Almost about 80.
About 80? And she was trying to be here this morning, but then couldn't make it. You said she doesn't normally drive, is that right?
She can't drive, so I guess didn't have a way to get her, because I went in and rented.
All right.
Brother, me locked up on getting the appointment.
Naturally, I'm about to get to that, because back in September of last year, you got in trouble for drugs, and we agreed at that time to revoke it, extend for a year, and that you'd have to attend and complete intensive outpatient treatment. Is that right? Now, it looks like you actually did complete the inpatient treatment.
Yep.
However, basically, as soon as you got done with the treatment, failed for drugs again. Is that right?
Yeah.
All right. And got basically immediately violated, locked up, and here you are.
Yeah.
Now, you claim that you're on probation, and you've had twice now problems with drugs, 3, depending on what that first one was for. But what happened with you? You know, you completed this treatment program, and then right away.
I was completed the program. I was informed by Mr. Potter that if we did a review there, we would do it. Going to go on what I was doing. When I went to my probation officer, there, what I was doing at training. I said I was working and going home. That's what I did. He said that was unacceptable, that I had to figure out something else for the interview. Around Friday, during that time, I wrecked my vehicle, so I didn't have any medication. I called a friend to go to a meeting, and just put in a position that I'm going to, just putting on.
Understood. You're hopeful and ambitious that the judge will consider letting you back out, if not right away, eventually, of course. And I know you have been on a long path, as it were. Is it still your intention to pursue sobriety, to stay away from drugs and try to stay on the straight and narrow? What sorts of things, if you were to be put back out on probation or community correction, would you do or need to do in order to make sure you maintain sobriety?
So if I was able to get out on correction, my supervision would be a whole lot stricter. That way my movement would be limited. I've got an A&E assessment appointment that I canceled from Centerton.
Centerton, yes, sir.
I can cover out of my own pocket, and like violations, I canceled that appointment. So I didn't want to wait, $300, $300 walk to the door and go through that and do another program I was even did do during the day. I had to miss work, which my boss accepted it, the work flow, we can only work sometime work picked up. I'm not really able to do during the day and finish on the contract. So I could do it at night online, and have the work finished on. I don't know details of exactly how it works, I didn't make my.
Now, you brought this up and you would ask me to bring this up, the idea of asking to be placed on community corrections. Do you consider you were on community corrections before, is that right? And when you were on community corrections, how was that different from when you were on regular probation?
Well, my roommate's friendly, so I have the free time to go run around with friends and do that. I'm limited. And so I'm waiting, they want to run the block.
And your proposal today is that you think if you were to be put out on community corrections, you believe that you would live on community corrections, correct? And that you'd be able to provide any treatment necessary, that you would attend an alcohol and drug assessment, say you already had set up anyway. And otherwise do as directed by community corrections probation with the judge. Is that right? I'm going to go back and talk about your mother just a little bit because I know she wanted to be here and she wanted to testify to it. But your day-to-day duties as far as taking care of your mother, what kinds of things would you ordinarily do for her during the day?
During the week, like once or twice a week, I would take her to the dollar store or take her to supply grocery store. We would do an online order for the tractor supply, like dog food, pet food, pup pads. That's the work I would pick up and take to the house and bring in the house. If there are areas in the house for the weight, twice a month, I would carry her to Fort Campbell, the commissary, and pick up her prescriptions. On hold. And basically whatever's needed in the house, clearing up the trash, cleaning the animal, mowing the yard. When things like that needs done, he was just when they were to do it.
Understood. No further questions, John.
They have questions?
All right, Mr. Phipps, my name is Brooke Allen and I work for the state on the prosecution side. Did you testify that you were having issues with transportation?
I wrecked my vehicle previously and my fault. It didn't let me use the vehicle, but it was not registered. We wanted to get that registered before I was able to use it, which there was about a week there that I did not have a vehicle.
So do you have a vehicle now?
I will have the vehicle that you provided me when I get out there.
And do you have a driver's license? That may have already been asked. I apologize. Okay. And you know that your violations are for meth. You're testing positive for meth. Is that right? Would you agree that that is an issue that you have, addiction?
Yes.
Okay. And you're aware that Mr. Potter, your probation officer, offers the option of long-term treatment?
But I also feel that after me completing my program and me going to work and going home, that wasn't acceptable. So you put me in a position where I was just in the bed. I mean, like, had to be with other drug addicts, and when you get a group of drug addicts, somebody liable to slip off and
So you are not willing to consider going to a long-term treatment program if that meant that you were able to come back out on probation after?
I don't really, I mean, I treated a long-term rehab, but again, I'm always from me right now. He's done sales life with me not being there, being there talking and so for help. So in the I do a long-term rehab, but I could also do the practice of some sound like I was doing team and with the supervision, I wouldn't be subject to.
Have you done classes before?
Yeah, I did a whole restored I think, I'll reject the date.
Do you think that you need the classes, or do you think that you personally just need stricter supervision? So what happens, so let's say you get out of these corrections and you violate that, what happens next?
Then I have a lot of work. Go through.
You don't want to take the option of off treatment.
I think we've heard enough.
That's all I've got.
Marlene, attorney, I'm over there.
But
Marlene, attorney, I'm over.
step down and have a seat with your lawyer. Either side wish to be heard in an argument, or do you have any other witnesses?
No, Your Honor, wait, guard.
I think the most telling part of this situation is that a couple of things. Number one, he was placed on probation originally in January of 2020 for possession of methamphetamine with intent to distribute. And he was given a sentence of 6 years. And then he violated the terms of that probation. And I think more than once, but at least the most recent one that I'm concerned about is that he appeared before me in November of 2024 and admitted that he had violated his probation, and we gave him another chance. We extended his probation for a period of 1 year, and he was revoked and reinstated and extended for 1 year, and he must enter and complete a long-range treatment, an IOP, intensive outpatient rather. That was on November the 20th. And then following that, on it was a violation of probation that was issued on March the 20th of 2025, and he was arraignment was set for March 31st. And on that day, he was present, and Judge Turnbow appointed the public defender and set the VOP hearing for May the 12th of 2025. On May the 12th of 2025, the defendant and the public defender were present for the VOP hearing. Judge Larry Wallace reset the VOP hearing for today and advised the defendant to report to probation and pass, because he was on bond at that time, and pass all drug screening. Keep in touch with his attorney and not to pick up any new charges. I have an amended violation of probation, which alleges that not only, I think the original one, he had tested positive for methamphetamine on February the 27th of February the 7th of 2025. And I issued that March violation of probation warrant that was reset. And when Judge Wallace reset it, one of the things he told him to do was to pass all drug screens on May the 12th. So he was given that opportunity, he was on bond, told to make sure he passed all drug screens. Well, on June the 2nd, less than a month later, he tested positive for methamphetamines and amphetamines, in direct violation of what Judge Larry Wallace had told him. So he clearly has a drug problem, a severe drug problem, but he doesn't really acknowledge that. Instead, what he says, he has a supervision problem, that he wants us to stand over his shoulders and to tell him exactly what he can do and what he can't do. And that as long as that's happening, that he thinks he can comply with the terms of his probation. In other words, he doesn't want really treatment for his addiction, which clearly he still has. He wants to be supervised in a way that he has somebody looking over his shoulder to keep him on the straight and narrow. It is not the function of this court to babysit criminal defendants and to make sure that they do exactly what they need to do when they need to do it. It is the function of this court to ensure that the laws of the state of Tennessee are complied with, and that a person who is charged with an offense is given a reasonable opportunity to straighten out their life. And you've been given more than one reasonable opportunity to straighten out your life. You've been given multiple opportunities, including opportunities that I have given you, and that Judge Wallace gave you by ordering that you comply with all drug screens and not pass all your drug screens and do everything else. So it is this court's opinion that we have bent over backwards to try to help you and that has today come to an end. Therefore, I find that you are in violation of your probation order. Having found you in violation of your probation, I revoke you to serve the balance of your time with all your credits. That's the judgment of the court.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?